The Supreme Court of India dismissed the appeal in the matter of KASIREDDY Upender Reddy versus State of Andhra Pradesh. Court clarified that it shall be open for person arrested with KASIREDDY Raja Shekhar Reddy and in judicial custody as on date to apply for regular bail before the competent court. This appeal arose from the judgment and order passed by High Court of Andhra Pradesh at Amravati dated 8th May 2025 by which writ petition filed by appellant seeking a writ of habeas corpus on ground that his son Kessireddy Rajashekhar Reddy came to be illegally arrested by the CID and is in unlawful detention came to be dismissed. The son of the appellant herein, namely Kessireddy Rajashekhar Reddy, came to be arrested on 21st April 2025 in connection with crime number 21 of 2024 dated 23 September 2025, registered with CID Police Station, Mangalagiri for the offence punishable under sections 420, 409, read with section 120B of Indian Penal Code respectively, read with section 61.2 of Bharatiya Nyaya Samhita 2023. It appears from the materials on the record that on 19th April 2025, son of appellant was arraigned as accused number 1 by way of entry in the case diary. The son of the appellant was arrested at around 6 p.m. from Hyderabad airport. At time of arrest, grounds of arrest were supplied to him and later were also served on his father, who was the appellant. Pursuant to the arrest, son of the appellant was brought to Vijayawada and was produced before jurisdictional magistrate, that is special judge for SPE and ACB cases, Vijayawada at 5:15 p.m. on 22 April 2025, that is within 24 hours of his arrest. In this appeal, court said that our endeavor would be to consider whether grounds of arrest supplied to appellant's son at time of his arrest could be said to be meaningful and sufficient enough to give a broad idea to person arrested of the accusations leveled and as to why he was being taken into custody. In the case of State of Bombay versus Atmaram, it was held by the court that the test is whether communications of ground of arrest is sufficient to enable detained person to make representation at earliest opportunity. In the case of Maganlal Jivabhai, it was held that the only possible and reasonable construction that can be put upon language of Article 22(6) is that detaining authority while furnishing grounds of detention is required to state the facts on account of which he is satisfied that detention is necessary in interest of security of state, maintenance of public order, etc. The object underlying the provision that grounds of arrest should be communicated to person arrested has been very succinctly explained in Vihan Kumar case. On learning about grounds of arrest, the person concerned will be in a position to make application before appropriate court for bail or move High Court for writ of habeas corpus. Further, the information will enable the arrested person to prepare his defense in time for purposes of his trial. For these reasons, it has been provided by Constitution that the ground for arrest must be communicated to person arrested as soon as possible. For purposes of Clause 1 of Article 22, it is not necessary for authorities to furnish full details of the offence. However, information should be sufficient to enable arrested person to understand why he has been arrested. The grounds to be communicated to arrested person should be similar to the charge framed by the court for trial of the case. It is a rule of common law and is described in different languages by different authorities, but the meaning is same. Arrested person must be told for what he is arrested or be informed of the cause of his arrest. In the United States, the accused has the constitutional right to be informed of the nature and cause of the accusation in the Sixth Amendment to the American Constitution. Professor Glanville Williams, in his article Requisites of a Valid Arrest in Criminal Law Review at page 16, criticized the reason given by Lord Simons as somewhat legalistic because very few people know the law of arrest in such a way that they can be decided on the spot whether the arrest which they are being subjected to is legal. In his opinion, true reason is a different one. Example, the reason given by Viscount 11 Simon LHC in the same case at page 588 in the following words. If the charge on suspicion of which the man is arrested then and there made known to him, he has the opportunity of giving an explanation of any misunderstanding or of calling attention to other persons for whom he may have been mistaken, with the result that further inquiries may save him from the consequences of false accusation. In United States versus Cruikshank, reported in 1876, it was observed by Wade CJ that the accused is given the right to have a specification of charge against him in order that he may decide whether he should present his defense by motion to quash, demurrer, or plea. The debates of the Constituent Assembly which framed the Constitution are relevant for purpose of ascertaining the reason behind the insertion of certain article in the Constitution. In draft of the Constitution, article corresponding to article under consideration was Article 15A. The reason given for inclusion of said article was that it contained safeguards against illegal or arbitrary arrests. It was given in the ninth page on Constituent Assembly debates on page number 1497. Also, it was given Vimal Kishore Mehrotra versus State of Uttar Pradesh case. Court said that if a person is arrested on a warrant, the grounds for reasons for his arrest is the warrant itself. If the warrant is read over to him, that is sufficient compliance with the requirement that he should be informed of the ground of his arrest. If he is arrested without a warrant, he must be told why he has been arrested. If he is arrested for committing an offense, he must be told that he has committed a certain offense for which he would be placed on trial. In order to inform him that he has committed a certain offense, he must be told of the acts done by him which amounts to the offense. He must be informed of the precise acts done by him for which he would be tried. Informing him merely of the law applicable to such acts would not be enough. In the overall view of the matter, more particularly having gone through grounds of arrest, court said that we have reached the conclusion that requirement in terms of para 21b as laid down in Vihan Kumar case could be said to have been fulfilled.